Good evening. I am delighted to welcome you to our Completed Life April Town Hall on Alzheimer's and patient advocacy. My name is Sarah Kiskaden-Bechtel, and I am the Program Director of the Completed Life Initiative. Tonight, I'm honored to be joined by speakers Dr. David Gruenewald, who is a geriatrician and Associate Professor of Medicine at the University of Washington, as well as Professor David Hoffman, who is a Columbia University lecturer in bioethics, Chief Compliance Officer at Carthage Area Hospital, and esteemed advisory board member here at the Completed Life Initiative. Tonight, David Gruenewald and Professor Hoffman will be taking a deep dive into the realm of Alzheimer's, dementia, and patient advocacy. Both David Gruenewald and Professor Hoffman have extensive professional and professional experience advising and advocating for individuals diagnosed with dementia and Alzheimer's disease. Before we turn to Professor Hoffman to begin the presentation, let me briefly mention that a recording of tonight's town hall will be available a day or so after the event concludes. And for those of you on our mailing list, you'll get an email once the recording is ready. And if you happen to be joining us for the first time, please go to our website and join our mailing list. Happy to have you join the Completed Life community. Throughout tonight's event, we welcome your submission of questions for Dr. Gruenewald and Professor Hoffman into the Q&A box on the right side of your screen, as well as the chat box also on the right-hand side of your screen. Either one will send a question to us, and we'll get to your questions later on in the presentation. So now, without further ado, over to Professor David Hoffman to give a brief overview of tonight's discussion topic. David, hello and welcome.
Thank you so much, Sarah, and welcome everyone to tonight's conversation. And let me stress that this program, like all of our programs, but perhaps a little more so, is really intended to be a conversation and a coming to terms with the personal and professional. So Sarah, if we could start our slides, we'll dispense with the usual acknowledgement of interests, competing interests, and conflicts of interest. So next slide, please. Both David and I, and feel free to refer to us in the chat as Gruenewald and Hoffman, it just saves syllables, are here with no financial conflicts of interest to express. Dr. Gruenewald wants me to stress that his presentation tonight are his views alone and not that of the Department of Veterans Affairs of the U.S. government. Likewise, I am only speaking for myself, not the Completed Life Initiative or Columbia University or any of my hospitals. And really what we're here for is to bear witness to the fact that the personal and the professional are inseparable. Next, please, sir. So what we're going to do tonight is sort of confront the concerns that everyone has with dementia as a prospect and as a diagnosis, both personally and as family members, and deal with the reality that suffering can't always be relieved. So we're going to look at this from the perspective of a clinician, whether a medical clinician in the case of David or a bioethics clinician in my case, and how we have to understand the way organizations view the desire to advocate on behalf of families so that we can be better advocates, because there are real concerns that organizations have, and we should understand them so that we can manage them better. And then finally, at the end of the evening, we'll take a quick look at a relatively new law in Nevada that really, for the first time, explicitly opens the door to rejection of assisted oral nutrition and hydration via advanced directive. So that's our plan. Next. So why are we here? How did this get started? Really, it was my learning about Susan Sarin, the woman pictured here, from David's and my colleague Judy Schwartz, who you'll hear more about later, who got to know Susan Sarin because of Susan's journey, which was interestingly chronicled in the Washington Post. Next, please. And it's a journey of discovery for her and for everyone who was involved in her case. And of course, also we're here because David and I, in addition to being professionally engaged in patient advocacy and care, we are both the sons of Alzheimer's. Both of our mothers were afflicted with Alzheimer's. David's mom just passed. My mother is in the late stages of her disease. And that is part of the advocacy story that we want to share so that you will all understand. Next.
All right, I'll take over.
Introduce your mom, please.
Yes, she was quite an innovator in her role as a registered nurse, having developed the consulting nurse model of care in 1970 and kind of taking that show ultimately to the point where it became a national and international model. After she moved out of the emergency department where she developed that role, she became a trainer and an advocate for nurse educators and for the support of nurse managers. And then she retired. It was a so-called retirement because she had a whole second career after her retirement as a nurse, a career as an author. And I'm showing the cover of her second memoir here. She had two books that she authored in her 80s. And this led to also a role as an activist because she spoke in her memoirs about what it was like to be incarcerated during World War II in the camps for Japanese Americans. And she didn't want that to happen to other marginalized groups such as American Muslims. So clearly she was a dynamic person and a planner. And one of the things that I was aware of for many, many years as an adult was she was planning for her eventual death. And she wanted us adult children to know what arrangements she was making. And she, long before it was a common thing to do, took out a long-term care insurance policy, eventually used it. And she would say things like, when it's my time to go, I am ready. And what I'd really prefer is that you just put me on an ice floe and let me float away like the Eskimos might do. And so we felt that she was very well prepared and everything looked good until she developed cognitive impairment and frailty at the end of her 80s. And at that time, she was becoming more and more distressed about what she would face, and in particular, what we adult children of hers would face. And because I was a physician and because of our relationship, she turned to me to talk about her worries, her fears, and her plans. And she knew that she had the option to stop eating and drinking long before this was something that was discussed openly in medical circles. And I didn't really know anything about the literature in this area, such as it was. And I started becoming concerned. So now we're at 2013, 2014. And she was thinking, I think I might do this. And I started worrying professionally, how is this going to reflect on me, knowing that we are people who are known in our community and word might get out. And how would this be viewed to me professionally if I were thought to be complicit in an unethical suicide attempt? And so it was time to bring this whole conversation out of the closet. We had a family meeting, including my mother, my brother, and sister. We also met with her primary care physician, who is also my doctor, and we just kind of unpacked this. And I wanted to know, Mom, why do you want to do this? What is it that really bothers you the most about facing loss of memory, loss of function, and possibly progressive Alzheimer's disease as you age? And I might add, she didn't have that diagnosis when this conversation was all going on. But it turned out that what she worried about the most was burdening the three of us with the demands of caring for her, both physically and financially. And yet she had done all this preparation. And so part of it was just kind of letting her off the hook a bit. That, Mom, you have done so much to prepare. And not only that, you give in so many ways to us as your family and to your friends and to the larger community in the legacy that you've left and continue to leave and the friendships you develop. So the upshot was that she decided, okay, if I have to do this, I'm not happy about it, but I will accept that I'm going to continue to live in an assisted living setting, which is where she was at the time. And by 2019, by the beginning of that year, she needed nursing home placement. And in each phase, she adapted. So this is kind of a best case scenario that I'm describing. She had advocacy for her wishes. She had resources, and she had knowledge that we had her back. We were going to be there for her, and we were going to do everything possible to work within the system and the reality of her illness to guide the care and, as best as possible, make sure that this is the best possible life until the end. And that is how it turned out. Even though there were bumps along the way, times when she would get very confused, agitated even. I remember at one point she thought she was on a ferry going to Vashon Heights, which is the family home on Vashon Island. And I had to talk her down late in the evening. And I mean, these are the kind of things that one has to do as a family member. But she did adapt, and for the most part, it was a good quality life. And I want to say, advanced care planning needed to be adjusted over time. And early in 2018, when these dementia directives started to become more established and available, we filled those out together. So part of my advocacy was supporting decision making. And she was, until very close to the end, able to participate in medical decision making, not independently, but unlike many people with dementing illness, we still have that conversation ongoing, and honoring her agency was very important to me. So why don't I stop here, but if you'd show the next slide, I just want to show you this picture of my mother in 2017. Now keep in mind, she had been hospitalized a few weeks before this picture was taken with a stroke, and she was still at the end of her rehabilitation phase. But we had made these arrangements for her to graduate from Vashon High School 75 years late, because at 17, her family was removed from the family home and incarcerated. So this was an example of still having a good life and enjoying the heck out of it. So I'll turn it back over to you, David.
Thank you very much, David. Next. So my mom's story was in some ways very similar to David's mom, and in other ways completely different. My mom was too busy living life to even think about it ending. That was part of her engagement on the one hand and part of her denial on the other. And she, like David's mom, embraced every possible opportunity. So later in her life, what at the time I thought was ancient, 45 years old, she decided to take up scuba diving at my suggestion. And it literally became the driving force in her life. So there's her on the upper right with a giant lobster, and on the left, scuba diving with manta rays. And it literally defined joy for her. So much so that in the middle, you see Edith and I on her 81st birthday going diving under the Pontoquag Bridge, one of our favorite shore dives. And it was a bittersweet moment because it was glorious to be able to go scuba diving with my mom at 81. And yet, during the course of that scuba dive, I knew that things were changing profoundly because Edith was a woman who felt most comfortable in the water over anywhere else. And I could tell that she just didn't remember all of the processes involved in safe scuba diving and felt nervous about it. And that was a sign of things to come. So shortly after that, we realized that, like David's mom, she was going to need some help. So we arranged for her to move into an independent living facility. Next slide, please, Sarah. So that she would be in an environment where she had the supportive care that she needed, but would still have a substantial amount of independence. And that went along fine until we got this letter, which was her eviction notice from the long-term care national chain that managed the building she was living in. Next slide, please, sir. And the interesting part of that was this paragraph. It starts off very lawyerly. Take further notice that the facts upon which operator's involuntary termination of the service agreement is based upon the fact that, and now it gets personal, as you are aware, Ms. Hoffman is attempting to leave the community in a manner that could put her at risk and wandering in the halls of the community. She has also advised that there are people in her room when she was found alone. In light of these circumstances, you leave the operator no choice but to terminate her residency at the community. And Edith's transgression was that she liked to go for long walks along the Hudson River. And she'd be gone all day, which is sort of the definition of living in an independent living facility versus an assisted living facility. And yet institutional forces that we're going to discuss now in some detail led her to be a threat to the business model that was being entertained. Next slide, please. So back to Susan Sarin, who had a similar experience. Susan was a commodities trader in Chicago and living a very vigorous life. And she was taken aback when she was told, as you can read in this Washington Post article, no protected health information here, that she had frontotemporal lobe dementia and that she was in less time than one would imagine, in fact, less time than with Alzheimer's dementia, going to be debilitated and dependent upon others for her care. So she picked herself up and moved from Chicago to the town of Ithaca in upstate New York, home of Cornell University and Ithaca College, and set herself up in another national chain of, in her case, assisted living facilities. And she thought that she had taken care of everything, sort of like David's mom. Next, please. But it turned out that she got the order of her steps in preparation a little backwards, couldn't have known it at the time. And tonight's program is so that you will learn from her difficult experience. As the article recounts, and now, upon arriving at Kendall, she is fighting with that community, interesting the use of the word community to describe these facilities, over her right to determine how she will die, even though she has made her wishes known in writing. Similar conflicts could ensnare many Americans with dementia who complete similar advanced directives in coming years. Next, please. So what this is all about is what happens to you as you age and advance into dementia. And it's important for all of us. David and I traveled this road, and some of you may as well, to understand how communities, how these facilities view the loss of functional capacity and how they evaluate and categorize residents in these facilities, something that we have to be prepared as advocates to manage. So David, can you walk us through the FAST scale?
Well, I just want to focus on a couple of things. Mostly, as the name functional assessment staging test implies, this has to do with a person's functional state at various stages of the disease. And really, the thing that most people worry about the most who think about living with dementia is the final stage, in which the person becomes essentially uncommunicative and unable to do much of anything except possibly to open one's mouth and be fed. And when people comment to me in these conversations that we have in palliative care about, I don't want to be a vegetable, a lot of times it is this state that people are saying, I don't want to be like that. Now, up until this point, my mother, when she died, was in stage 6 of her dementing illness, but still quite able in many ways to participate. And so she was different than some other people in stage 6 because she had the capacity to participate in medical decision making. Participate, but not to totally decide independently. And that's what's not on the FAST stage scale is, does the person have capacity to participate or to make medical decisions? So I just think that's worth pointing out.
Slide one. Go ahead, David. I'm sorry. There we go.
Yeah. So this is sort of a breakdown of what was on that table. But at stage 6, where my mother was, she did lose most of her activities of daily living, although she was able to feed herself. She never did lose that to the very end. But she had clearly moved through the stages, and for her it was a little bit more stepwise, like more of a stroke dementia kind of scenario. For others, that capability to make decisions may be lost quite early on, and we will talk a little bit about this window of opportunity to make decisions about one's own care and fate, because that's really important. So that's mainly what I wanted to say. So I'll turn it back over to you, David.
Thank you, David. So my mom, just to put this in some context, is now somewhere near stage 6 3/4, right? She has some awareness of her surroundings and has a few words, although with the impact of COVID, maybe that's actually gone now and we're just kidding ourselves. But she is at that final rung of this ladder, which again is a functional assessment. It's not a cognitive assessment. We have different tools for that. But this describes the circumstance people often find themselves in. And as David said, this is when people often want to assert their rights. So what are our rights? Well, the law describes some of those rights, and in some respects, they are more subjective and ethereal. Next, please. So the first right takes us back to 1914. So when you think about 1914, that's what a car looked like in 1914. And this is what happened in 1914. Benjamin Cardozo articulated and wrote these immortal words: "Every person of adult years and sound mind has a right to determine what shall be done with his own body." Although Mary Schlowendorf was a woman, it was 1914. Next, please. And that notion of a right to control what is done to you gave rise to lots and lots of laws and regulations. Here we have a sort of archaic description of one particular rule. We're going to talk about this a little bit. This is from the Code of Federal Regulations, CFR. Next, please. And these are the rules that entities, organizations, facilities like Kendall, like Atria, like the place that David's mom lived, these are the rules that they live in some fear of. And can I tell you, I live in some fear of them as well, because I have in my group of hospitals 2 long-term care facilities, a nursing home and a assisted living facility. And it is pretty serious if the federal or state government determines that you have placed a patient or a resident in immediate jeopardy. So we really strive to stay away from placing patients in immediate jeopardy. And for better or for worse, that can result in institutions making decisions, such as was made in my case, to prioritize risk aversion over patient autonomy or independence. Next, please. So along with these rules, the government provides some training. The training is contained in a part of the State Operations Manual. If you're interested in all of this law, we have other programs on that subject. And Appendix Q describes a few of the kinds of scenarios that can be defined as immediate jeopardy. And we're going to be concerned with that middle one. Next slide. Which is the definition of failure to provide adequate nutrition and hydration to support and maintain health. And the specifications for that are food supply, meaning literally having it in the building, inadequate to meet the nutritional needs of the individual. And then more specificity, failure to provide adequate nutrition to an individual, resulting in malnutrition, example, severe weight loss, abnormal lab values. And then third, withholding nutrition and hydration, my emphasis, without advance directive, or lack of potable water supply. Go figure. So withholding nutrition and hydration without advance directive is the key to advocacy around this risk aversion that we see oftentimes. Next, please. So in this State Operations Manual, SOM, they give the surveyors, the people who enforce these rules, some examples, and this is one that is actually directly on point. Confused and debilitated 75-year-old female admitted as an inpatient to the hospital has orders to discontinue all nutrition and hydration. We would call that VSED, or stopping eating and drinking by advance directive, and that can constitute immediate jeopardy. Next, please. And the example given, and this is what we all need to be cognizant of, these are the ways that the organizations are concerned they will be critically examined. During the investigation, the surveyor finds that the chart does not include a copy of the patient's advance directive, and there's no documentation that the patient ever stated a wish to have nutrition and hydration withheld. Next. Now, this is interesting because in this training example, the government says or describes the patient has been admitted because of continued weight loss and dehydration related to the refusal to eat and drink. So even though this patient is suffering from some measure of dementia, she is demonstrating by her behavior what she wants and doesn't want. Next. So the problem develops when the investigation gets to this conclusion that the daughter, whom the investigator in this hypothetical has contacted, expressed a wish to have nutrition and hydration, never expressed a wish to have nutrition and hydration withdrawn. And when contacted, the daughter is unaware that support had been withdrawn and is very upset. Next. So why does all of this matter? Well, it matters because the institutions are going to react to protect themselves from being accused of withholding legally required care unless there is an advance directive that clearly spells out that that is the patient's wish. And sometimes even then, things can go wrong. So David, talk to us about this notion of dementia worry.
So sure, thank you. Many people on this presentation today are probably thinking about this question, and it may be the reason that you are here today to talk about this. People think about that last stage of dementia and may worry a lot about prolonged dying in a state of severe cognitive and physical incapacity. And some people, as my mother did in 2014, start to think about, should I take action today while I can during this window of opportunity to hasten my death? In effect, I'm going to die now, so I never have to go through something like that. If my mother had decided to die at that point, she would have lost 6.5 years of what turned out to be high quality living. And for some people, there may be the chance that life may be high quality, and for others, maybe life is already pretty miserable. But even then, we can't always know what the trajectory is going to be. And sometimes there is this phenomenon called response shift, where people who are faced with the reality of disability or some other problem like that will say, I thought this was going to be really bad, but now that I'm here, maybe I can learn to live with this. So that trajectory is often a big black box that cannot be fully known. But then there's the flip side, that if you don't act now, you might end up in that worst case scenario. And that is why dementia directives are being developed. And we have some examples to look at. Next slide, please. The traditional directives, like the living will, have some problems with them. Most living wills say something like, if I develop a persistent vegetative state or I'm dying very soon, at some point stop torturing me. That's about all they say. And that's not helpful when it comes to guiding care in general, but it specifically doesn't address the concerns of people who are pondering how they want to approach that question of stage 7 dementia. Now, the way providers often behave, unless there is a specific known directive to the contrary or a conversation to unpack this fully, is we just kind of continue along our merry way with usual medical care. We'll manage the hypertension and the diabetes and other problems like that, even as dementia progresses, without thinking, maybe I need to adjust the advanced care planning situation. But when we ask patients what they prefer, many times they'll say, if I look like I'm getting demented, I want you to ramp down the aggressiveness of usual medical care and increasingly focus on comfort-oriented, quality of life-oriented care. So this notion has given rise to the initial foray into dementia directives. And I give an example here called, that's available at dementiadirective.org. And one of my colleagues at University of Washington Dr. Gaster was instrumental in designing this directive. It's a very simple directive that calls for changes in the care plan as dementia progresses and functional or cognitive milestones occur. But what's missing from the Gaster directive is there's no mention of oral nutrition and hydration, and this becomes paramount as we think about how advanced dementia progresses. Next slide, please. Another concept that I think it's crucial that people understand is the notion of comfort feeding only, or CFO. This is defined as assisted hand feeding that is given as long as the demented person is not showing distress signs with feeding. And that would be refusal to open the mouth, or coughing and choking with intake suggesting it's going down into the respiratory tree instead of being swallowed. And the focus of comfort feeding only is clearly comfort rather than maintaining nutritional state. And so we don't expect in comfort feeding only that weight is going to be stable, or that lab values suggesting adequate nutrition are going to be stable. Feeding is stopped if these distress signs develop. And this has become known in the last decade in geriatric circles and long-term care circles and even palliative care circles as, by many who practice in these environments, a best practice in the care of people with advanced dementia. But we should note that for people who are really thinking about hastened death as what they want and are preferring that over the risk of living in a state of prolonged incapacity, these kinds of directives that end up with comfort feeding only don't really totally fill the bill. Next slide, please. And so we have some examples like End of Life Washington, or Compassion and Choices has also developed a directive that specify milestones indicating when comfort feeding only should be stopped. And we mentioned some of these indicators like indifference to eating and drinking, or turning the head away when food is offered, or physical signs like gagging and coughing and choking on food and fluids. So these are subject to some interpretation, and that is where, for the person who is really thinking, I want to hasten my death if I get to a certain point, there could be problems. But in any event, even with comfort feeding only, it's crucial that the providers of care understand that the person is not to be forced to eat, to be cajoled or manipulated or coaxed under this directive in this plan. Now, I want to mention a more, what has been described by some as a more aggressive directive that was published by End of Life Choices, New York, in which there's an additional option, which is to discontinue food and fluids, whether provided orally or by medically assisted nutrition via tube, when the following conditions are met. When the person is incapacitated for medical decision-making, and typically that is because they now are entering a state of advanced dementia, and they become unable to feed themselves. And so even if food is pro-offered, and even if when the spoon is moved to the side of the mouth and the person opens the mouth, food is to be withheld. So that's a more aggressive stance that's harder to game than the other two types of directives that I mentioned. Next slide, please. So I'm going to turn it back over to David.
Yeah, so you may be wondering why we need to think about all of these different incarnations of advanced directives. And the reason is that the law has not always been kind to people who are suffering from dementia. And there are two prominent cases from the West Coast, and we're just going to describe them briefly. They are both available for research in greater detail, each of which is its own kind of tragedy. Next, please. So the first is Margot Bentley from Vancouver, British Columbia. She was a nurse, and she thought that she had taken all necessary steps in preparing her advanced directives, much like David's mom. And she wrote that she refused nutrition and liquids if suffering from extreme mental disability. And then she developed Alzheimer's. And the judge said that because she was swallowing what a spoon was pushed into her mouth, that was an indication that she had changed her mind. Think about that. Next. This next slide is upsetting, but it's important for you to see for the briefest moment so that you understand what happens to a patient who reflexively swallows when a spoon is put in their mouths when they have dementia and are in a long-term care facility. Sarah, just briefly. That's Margot Bentley. And that's the state in which she was being fed. The second case is in some ways even more tragic. Nora Harris, this is a case out of Oregon. She was a research librarian, a highly educated, very academic person. She developed early onset Alzheimer's, which is often the most serious and rapidly debilitating kind. At the age of 56, she completed advanced directives. She said that she didn't want to be fed artificially. She didn't want to prevent her, she wanted to prevent her life from being prolonged when the disease got worse, but she didn't explicitly mention assisted hand feeding. And so the judge in that case said, because she didn't say anything about hand feeding, she needed to be hand fed. She didn't die until 2017, 8 years later, at the age of 64. Next, please, Sarah. This is Nora, who looks kind of fine there with her husband. She had no idea who her husband was and lived in fear of all of the things that were unknown and uncertain and threatening to her in her debilitated state. Next slide, please. Another case, one that our colleague Judy Schwartz confronted in her work on behalf of End of Life Choices New York, involved a woman named Hannah. And Hannah's daughter actually called End of Life Choices to get assistance because she too had thought that she had done everything right and that her mother had prepared all of the eventualities so that she wouldn't wind up being force-fed. Next, please. So Hannah was spoon-fed 3 times a day by a very patient aide. And as Judy describes, she reflexively opened her mouth when the spoon was brought to its side like a baby bird. She was deemed terminal over 2 years ago, but hospice said that she must be continued to be fed until she forgets how to swallow. That's just horrific, right? So next, please. All of these circumstances and all of these court decisions have left long-term care facilities feeling like they need to protect themselves from uncertainty, and sometimes that leads to very aggressive oral feeding. Next slide, please. And what we are dealing with is the institution's reaction to both media coverage and legal enforcement actions and lots of other forces that are often a misinterpretation of what the law protects in the way of our rights. Next, please. So this is a letter written by a law firm up in Syracuse, New York, regarding Susan Sarin, where they said, next, please. The rules and regulations governing all levels of healthcare require healthcare providers to offer adequate nutrition to its patients. Next, please. But when they highlighted or focused on this notion of offer, the critical words in those sentences, offer and provide, were grossly misinterpreted to suggest that the facility had an obligation and the right to provide nutrition despite Susan Saren's explicit written objection. Next, please. And this comes from a conversation, literally a phone conversation, where the lawyer for Kendall spoke to somebody from the state health department who said that there is an absolute obligation to provide food and that the institution had no choice. Next, please. And this is just wrong, right? So the lesson that we can learn from Susan Saren, and the lesson I want all of you to take away from our discussion tonight, is that the analysis by counsel to Kendall is flawed specifically because of its reliance on a self-protective interpretation of statutes, ignoring the contrary guidance from the federal government, CMS, the Center for Medicaid and Medicare Services. Next, please. And that's because the interpretation is developed on the basis of the assumption that the patient's wishes are not known. And how do we know that? Next. Well, because of this. The requirements applied to providers, this is section 49.102 of that state operations manual, says that the long-term care facility is obligated to provide information to individuals, residents, including that an individual's rights under state law, whether statutory or recognized by case law, to make decisions concerning their medical treatment, including the right to accept or refuse medical or surgical treatment, and the right to formulate at the individual's option an advance directive. And in the case of Susan Saren, she had an advance directive that specifically said, I do not want to be fed when I no longer show an interest in being fed. Next slide, please, sir. So the rules go on to say that this right is not, that the provider's obligations are not the condition of the provision of care or otherwise discriminate against an individual based on whether or not the individual has executed an advance directive, meaning that people who prepare advance directives can't have their rights taken away from them specifically because they have prepared an advance directive. And next and final slide, sir. These regulations conclude, and this is what's so maddening about the Susan Saren case, the regulations conclude that the provider listed in paragraph A of this section, the facility, are not required to provide care that conflicts with an advance directive. There you go. So let's take a break now and see what kinds of observations, questions, or concerns all of you have that maybe David and I can help you with. Sarah, do we have questions?
Thank you, David. There was a moment of transition there. Thank you both, David Hoffman and David Gruenewald, for just an incredible and heart-wrenching presentation. We have some questions coming in, so let's get started. Gary Wiederspan asks, are there cases where dementia advance directives are disregarded by religious healthcare organizations?
You know, part of the problem is that we don't have great data on that. We know anecdotally that religious organizations with some frequency impose a cover of religious doctrine over the way they provide care for patients. And sadly, oftentimes the patient doesn't know that when they enter that facility. So that's a concern that we have to grapple with, right? And part of the way we do that is to educate patients and their families to ask these questions before they sign on the dotted line, or as in the case of Susan Sarin, hand over $500,000 to pay for the care she knew she would need for the rest of her life. David, any thoughts?
Yes. So these kinds of directives are fairly new, and many facility administrators and clinicians are probably not that familiar with them. And so there, as you say, there's not a lot of track record, whether it's legally, clinically, or ethically, for how to navigate these waters. So it's still very much a fluid situation. But even when a person in a facility wishes to stop eating and drinking and they have decision-making capacity, there are still barriers. There are still barriers because of that risk-averse mindset that facility administrators bring to the table, and the survey considerations. And really what is necessary is to think about, what does person-centered care planning look like in a situation like this? And I think, David, this is really what you're trying to get across, is let's get back to the person and what is person-centered care planning here? And what is happening is not person-centered. The challenge is that people are afraid. I mean, just as I was afraid in 2014, because I didn't know what I might be facing. And so we really need to be having this conversation right now, because this is going to come up more and more.
And by the way, we're trying to get an answer to the question that was posed, and I'm actually launching a major national research project where we are circulating a questionnaire to the medical directors of all long-term care facilities to ask them in a polite and sensitive and respectful manner, what is your experience with advanced directives at the end of life for dementia patients? What are your concerns? What are your practices? What are your policies? It's my hope that the information we glean from this project will enable us to educate and advocate for better practices within these facilities that balance the concerns of the institution about a finding of immediate jeopardy against the need, legal and moral need, to respect the wishes of the patient as expressed in an advance directive, as was illustrated by the regulations we discussed. Next, Sarah.
Thank you. A question from Carolyn Van Ness. She's wondering, in the event of early Alzheimer's, can a family member intervene with a verbal example that the person wanted not to live this way, or is it only honored if done before loss of cognition?
Seems like that's more of a lawyer question, David, so I'll start. I'm reminded of the quote of P.T. Barnum, who said, oral contracts aren't worth the paper they're printed on. The reality is that oral statements of the individual's prior expressed wishes can and should be relied upon. That is set forth in New York State, for example, in the O'Connor decision and in the U.S. Supreme Court decision in Cruzan. But it's difficult to get an institution to accept that oral representation, even if it meets the very high standard of evidence of the patient's clear and convincing wishes. And so, though yes, legally that ought to be respected, you're always going to be better off with a written document and maybe even a videotape of the individual articulating in their own words what their wishes are.
Yes, I might add, from a clinician's perspective, we should not always jump to the conclusion that a person is incapacitated and unable to participate in medical decision making. So, as an example, my mother from very early in the process, she was unable to remember from 1 minute to the next what had just been said. And yet she retained insight so that when the pieces were kind of put before her and what we were asking for is some reasoning and some understanding and some appreciation, she could string the thoughts together. As long as the blocks of information were right in front of her, she could string that information together then. But then 5 minutes later, we'd have to do it all over again.
Right.
So she was able to participate.
It reminds me of a rule that I drill into all of my bioethics master students' heads. And that is that when you're asked the question, does the patient have decisional capacity? There is only ever one response, and it's not an answer, it's a question. Capacity to make what decision? Because you can have capacity to make one type of decision, could be very serious but simple, and not have the capacity to make other kinds of decisions that are less weighty, but are just complicated in the amount of data you have to be able to hold in your head in order to make the decision. So we ought not to get hung up on the notion that if you can't balance your checkbook, that means you don't have the decisional capacity to accept or refuse treatment.
Thank you. Juliet Johnson wonders, since you've referred to various documents, what is the best advanced directive document to recommend to individuals who do not want to be fed when they lose interest and are unable to feed themselves? Your thoughts?
David, go ahead.
It depends on the degree of control you wish to have. If you want a high degree of control, you're probably best off choosing a document such as End of Life Choices New York, which really sets out some firmer guidelines on what should prompt the cessation of food and drink. Whereas if we are putting forth criteria that potentially could be quibbled with, then we're going to be having this debate. And just before we got on today's presentation, I was looking through the Compassion and Choices website, and they have this sort of algorithmic approach where you can really sort of identify like 20 different things that you can make a choice about what you would or would not want. I think that's pretty challenging to go through for somebody who is already cognitively impaired. But if you're doing this well in advance, you might be able to go through that process and come up with a very specific advanced directive. But the person who asked the question used the word best, and I always, best for whom and best for what purpose? I think you really need to be thinking about, where you are on that spectrum of, are you feeling like under no circumstances would I wish to live like this? And I'm willing to undertake a significant risk of leaving high quality or satisfactory years of life on the table unused. If I'm willing to take that risk, then maybe I need a much more draconian process. I might not even want to go there. I might wish to go to Switzerland right now. So you need to make that kind of a decision to determine what is best for you.
Juliet, the notion that you asked the question suggests that you understand this is a serious issue. And I agree with everything David said. I would add this. You can write a long and detailed document and miss the point, right? The challenge and the art of drafting advanced directives is in getting an adequate level of specificity and generality. And that's a skill. It's a skill, in fact, that I teach my students so that they can provide that assistance to patients and family members. So my advice on which is the best, it's the one that someone who understands the range of requirements suggests to you is the best. So ask for help. There is so much good help available from so many organizations across the country and around the world. So whether you want to deal just with the law in your state, or you want to know what are the options nationally or internationally, you might find yourself in a situation, as David said, where the constraints of the social norms in America do not give you the options that you want. And therefore you need advice on what other options are available elsewhere. So Switzerland, for example, provides a means for dealing with circumstances, medical circumstances, that no state in the United States, and frankly, not even Canada, and not even some other parts of Europe, permit residents or individuals, because you don't have to be a citizen of Switzerland to avail yourself of the range of options Switzerland provides. That literally can and will be the subject of an entirely other program that Completed Life Initiative will put on. But you need some advice. Let me close with this thought. A good, solid advance directive can be very simple. Mine is 6 lines. My personal advance directive says, I do not want to be a potted plant. If I am unable to express myself and experience joy, I want all care withheld except pain medication so that my passing can come quickly. That's it. You want to inform your surrogate of what you mean by all of those words, but a simple declaration of, I have an absolutist position on one side, or I have an absolutist position on the other side, or I'm somewhere in between. That's the best advance directive for any person. Sarah?
Thank you both. So now the flip side of that coin, from best version of the advance directive to no advance directive. And this question is from Barbara Sarah. She's wondering, if you have no advance directive, are you doomed to be a Nora or a Hannah?
No is the short answer, because there are lots of rules and lots of procedures and lots of opportunities that can protect you from an uncertain fate if you have a strong advocate. Right? So in now every state except Missouri, up until recently it was every state except New York and Missouri, family members can make decisions about end-of-life care for their loved ones. Not as many decisions as a family member can make if they are an appointed surrogate, and if they are an appointed surrogate with specific instructions about the patient's values and wishes, but there is still a good deal of discretion. But don't let me discourage you from preparing an advance directive. That is absolutely the best and most important thing you can do to make sure that you complete your life in a manner that is consistent with the way you lived it.
I would like to add that for the person without a directive, the role of the surrogate decision maker is to speak on behalf of what the now incapacitated person would have wanted. And so this is where that oral information that David was referring to is critical. What did this person say about conditions towards the end of life when they were capacitated? Oh, I would never have wanted to live like that person over there. Those kinds of statements and the way a person lived his or her life become critically important in a palliative care style conversation to unpack what is most important to this person. And now you are the spokesperson. You are the voice for what this person would have wanted. Were they able to say, here today.
Thank you. This next question is from Dina Davis, specifically to you, Dr. Gruenewald. She's wondering, how do you know that most persons worry most about the final stage? Do you have evidence? My sense is that many people would want their lives to end at an earlier stage, especially if they are concerned about their legacy, not burdening others, financial issues, etc. What are your thoughts on this?
I think that's a fair point. Many times this process can go on for years. And my mother died at 96, but if she had developed early onset Alzheimer's disease, and she was otherwise physically robust, she might have burned through her entire savings and resources and then had to spend down to the Medicaid level and be at the mercy of the state. So that's just one example of a situation where a person, just as you have said, may be concerned about the earlier stages and what is life going to look like then. It might be low quality living in stage 4, stage 3. Everybody's different. So I acknowledge.
Yeah, and I don't think what David has been saying is inconsistent with your observation. People who are focused on the earlier stages, by definition, are focused on that stage because they know they don't want to get to the further stages, and that's a legitimate and appropriate individual choice. What we have to be aware of is that when a person makes that decision, especially at the earlier stages, it can be that much more difficult to know what the future holds so that that can be an informed decision. My mom, for example, will be 87 in August. She's very far along. And this is not a way that she would want to live, but she's not aware of her circumstance. And part of the challenge of bioethics consultation around end of life for dementia patients is understanding what the advancement and the progression of the disease means. So for example, my mom, when she, right after that last scuba dive, when she was 81, when she started developing visual and auditory hallucinations, for a time they were kind of playful and odd. Then they got rather disturbing, and I was very concerned. And I developed techniques for literally helping her reason through her visual and auditory hallucinations. The one that sticks with me most dramatically, one day she called me up. She was in New Jersey, I was in Manhattan. She said, "David, you've got to come right over." Right? It was a 2-hour trip to get to where she was. I said, "Mom, why do you need me to come right over? I'm at work. I'm at the hospital." She said, "There's somebody shooting a gun at my front door." And I paused. This is when it's actually helpful for this to be your day job. And I said, "Mom, when was the last time one of these gunshots occurred?" And she said, just literally a minute ago. I said, "Mom, about how long was it when this started?" And she said, "Oh, it's been going on for at least 20 minutes. And I said, "Okay, Mom, go walk over to the window that looks out on the driveway to your complex. Tell me what you see." And she described everything in wonderful detail. And I said, "Mom, do you think if somebody was firing a gun in your hallway, there'd probably be at least a few police cars and maybe some fire trucks and ambulances out there?" And she said, yeah, you're right." And I said, "So Mom, I think maybe, what do you think? This might be one of those hallucinations that we've talked about." And she knew she had hallucinations, and yet when she was in one, that wasn't a hallucination. And this is where trust comes in, because I said to her, "Mom, I want you to trust me. Go over, look through the people, see if you see anyone out there. And if you don't, open the door and tell me what the door looks like." And she opened the door, and there were no bullet holes. And then she felt better. She went back to whatever she was doing. That's what it means to advocate and assist a patient who is living through these processes. Later, when she was in a memory unit and she started having problems with even the most rudimentary decision making, we stepped in. But when we would go to visit her, she would become incredibly tearful when we left. And it was heartbreaking, leaving me wondering, would we be better off not visiting at all? And that was a horrible phase. But guess what? That phase ends. And the patient, my mom, wound up in a different place where she was seemingly anyway at peace. I am very much hopeful that technology will enable us to have a better idea of what patients' level of awareness is as they advance through dementia, because it is agonizing and heartbreaking to have to guess about these things. Sarah?
Wow, thank you for sharing this experience with your mother. It's yeah, thank you for your vulnerability. Turning to our next question from Ann Spector. It's a two-part question. Part one, I'll start with. She's wondering, are there copies of relevant sections of federal and state law generally referenced in and appended to advanced directives? Would that assist both the facilities and or the courts in the event that the wishes of the patient were breached?
You know, I will say I wish that there were a legal or a drafting solution to this problem. I don't know that annexing some of the statutes that we talked about and others that we can talk about at a future event would make a difference. What you need to do is get good advice from a lawyer who has bioethical sensibility or a clinical ethicist who has legal acumen, so that you have crafted your advance directive to respond and reference the substance of these laws and regulations. You don't need to cite them. You need somebody on tap who's ready to make those arguments. And there are lots and lots of lawyers who are prepared to do this. I know because I've trained lots of them. So that's the best path, Anne.
And now to part two for question. It could or should also be possible for attorneys, if involved, and or organizations may assist individuals with advanced directives to keep a mailing list with which to update this information as that occurs to both the individual and their proxy to ensure that they are kept current. Also, in parentheses, adding that the facility, if it's where a patient currently resides.
So the best way of achieving that objective, Anne, is to get on the mailing list for the Completed Life Initiative, because this is literally our purpose, right? The Completed Life Initiative was founded just a little over a year ago. It's been quite a remarkable year for us. To dedicate effort and resources and attention to the notion that no one should have to approach this phase of their life without access to and awareness of resources that can assist them through each stage. And I think your idea of a mailing list or a subscription to regular updates on these legal changes is a wonderful idea that we can actually implement quite easily. Just get your name on our mailing list.
Thank you. So Heather Robinson is wondering how to get your hands on a copy of a document that will actually be an advanced directive that works. And she references Thaddeus Koch, who she mentioned must have dozens of these documents on his desk. What are your suggestions?
David, why don't you take this one?
Well, state by state, Compassion and Choices is an organization with resources in many states. in my own state of Washington, End of Life Washington is where I often go. And speaking to the prior question, I've seen updates recently on the End of Life Washington website. So that's a source of information that I feel stays current. So those are a couple of thoughts.
Yeah, so there are lots of organizations, and we are blessed to have the internet, which gives us a way of keeping up on these things. Thaddeus maintains his own website, which is quite wonderful. I use it all the time. He is just a wellspring of information on these topics from a legal perspective. But frankly, the best thing you can do is to continue to attend the events of the Completed Life Initiative and other organizations like End of Life Choices Washington, End of Life Choices New York, to stay on top of these things. Funny you should mention Thaddeus Pope. Sarah, can we jump to slide number 53? Because one of the first goals or missions of the Completed Life Initiative was to do just what you've asked, which is to bring to people's attention new laws that can give people new tools. So this is the end of life decisions addendum to a advance directive that Nevada put into statute to give people the ability to give a legally recognized and empowered designation about decisions at the end of life. Next slide, Sarah. And question number 4 in the Nevada statute goes right to this point. After asking 3 other questions about what you want done when you get to different stages of your treatment, question number 4 asks as a yes/no proposition, I want to get food and water even if I do not want to take medical treatment, take medicine or receive treatment. And under the Nevada statute, you can answer that question yes or no. Yes meaning that I want to continue to get food and water, even if I'm refusing medical treatment, or no, if I'm refusing medical treatment, I also want to refuse food and water. So this just happened a year ago, this past October, and there are some rather nuanced and subtle legal challenges in getting this model of advance directive recognized and enforceable in states other than Nevada, but guess what? We're working on it. So stay tuned.
Thank you, David. It's always great to plug the Nevada law, which is part of the origin roots of Completed Life. So thank you. And I will put that that Senate bill in the chat for everyone who's interested in a moment. But to follow up on our string of questions here, they're coming in fast and furious. So thank you all again for your great questions. This next question is from Elke Erdl. She's wondering to either or both of you, how old can this advanced directive video or document be considered valid, essentially? How long can it exist and last and still considered to be effective?
So David, do you have a clinical answer to that question? And then I'll give the ethical and legal answer.
The answer I would give is until it's rescinded, it's valid.
Yeah, that's the technical answer. From an ethics consultation perspective, what we would look for is evidence that the directive, whether it's a video or a document, contemplated the circumstance that the patient finds themselves in, either as a generality or in specific detail, and that there isn't any indication from family members or from treating clinicians that the patient changed their mind, or that we ought not to assume that a patient's advance directive about one circumstance would apply to a unanticipated circumstance, or the opposite. And the opposite is actually more interesting, because I had a consultation a year or two ago involving an individual who said, if I am suffering from a terminal illness, I do not want any care. I want to be allowed to die. And that patient had a stroke. Well, so what did the patient mean by terminal illness, right? We ought not to obsess about the medical definition of terminal or the medical distinction between illness and injury. Our job ethically is to get inside the head of the patient from all of the available sources of information and understand what the patient meant. This is a process that we describe in clinical bioethics as substituted judgment, right? You're projecting forward what you know of the patient's values in order to gain an insight as to what their wishes would be concerning a circumstance that they did not describe.
Thank you. So our next question is from fellow Completed Life Advisory Board member Peggy Batten. Peggy's has a question for Dr. Gruenewald. She's wondering, suppose a patient newly diagnosed asked you for your advice about how long it makes sense to continue with Alzheimer's, or where it would be best to stop if you wanted to maximize the amount of good life left, but to avoid the worst. What would you say to that person?
That's an invitation for a broader conversation about what matters most. And then a conversation ensues where we talk about, what do you worry about the most? And what's important to you? What do you care about? What do you fear as you live with X diagnosis? And it's the answers to those questions that help me give a response to that. Until then, it's me listening and clarifying and asking other questions that help unpack what is most important. So that's a palliative care conversation.
Yeah. For all of you out there, that is the kind of question that you have to anticipate from a philosopher who has spent most of her professional life thinking deeply about these questions. Peggy, I'm glad you posed that question to Dr. Gruenewald first, because I find your questions very challenging and very thoughtful. I would add this, Peggy. I think the question within the question is, can I identify a moment when I have achieved the most enjoyment of my life before I reach a point where I am not able to express or enforce or activate a decision that I don't want to wind up where I don't want to be. And to David's point, that has to be a bigger conversation, because obviously as a technical matter, we have no way of knowing when is the last moment of some quantum of joy, right? That's the dictate of my advanced directive. When I am unable to express myself and experience joy, I want all but pain care withheld. Knowing when that is, that's the tricky part. And that's what requires a conversation between a patient and their family member and their surrogate and their doctor and their resident philosopher. That's the only practical way of getting as close to that boundary zone as we are able to achieve.
Yes, and I would add that there may need to be further conversations as circumstances change. And if the person is no longer capacitated at that point, then the conversation is more and more with the surrogate, with the person who will speak on behalf of and be the voice of the person.
Yeah, I think the point Peggy wants all of you to understand is that even after you've lost your decision-making capacity for a particular decision, you still have values, you still have priorities, you still have preferences, And the notion, for example, of narrative ethics, something we're going to be discussing at an event next week with Danielle Spencer, is the notion that even when you lose your decisional capacity to make the decision that needs to be addressed in a particular moment, you still have the ability to direct that there be a consistent narrative thread through your life, and that insight guide how care decisions are made by your surrogates and by your caregivers.
Thank you both. So we are starting to run out of time, unfortunately, and I'd love to conclude with a question from our very own Dr. Timothy Quill, our clinical advisor here at Completed Life. First of all, he wants to thank you both for this moving and frankly terrifying presentation. So getting into his question, even when patients still have capacity, they may not be terminal enough to qualify for medical aid in dying. So stopping life support and voluntarily stopping eating and drinking, or VSED, seem like the only options, which may require acting before you really want to. If you do wait, are there any ways you can guarantee people will act on your behalf?
Thank you, Tim. So Tim and I did a program, it was either a week ago or a month ago or a year ago, it's all a blur, on palliative sedation. And if you're interested in the subject that is suggested by Tim's question, I urge you to take a look at that recording, which is available on the Completed Life Initiative website. I think the answer to your question, Tim, is the answer that David gave earlier, and that is to line up your team, and your team has to be your entire family and friend group and whomever you've selected as your surrogate and your backup surrogate. And you have to make sure, for example, through videotaped messages that can be viewed by your surrogate and your caregivers, and maybe even the administrator of your long-term care facility when you are no longer able to speak for yourself, so that all of those individuals can see who you were as a person and what your priorities are. I hate to say it, but if you are concerned about winding up in that situation, in addition to lining up a highly qualified and committed and tough clinician, you need to line up your surrogate and your ethics consultation resource, and yes, a lawyer who understands this complexity and has a fidelity to the values of patient independence and the duty that clinicians have to exercise their skills and their judgment and their authority with humanity and humility. And sadly, Tim just retired, so don't call him, but get someone just like him.
Yes, I agree, David, with what you've said, and the package is really important. And the more compelling that video presentation, the more complete, the more clear the reasons why the person wishes to avoid living in that state and the remedy they are asking for, the better off it will be, and the easier time a surrogate will have to say, oh yeah, I remember that discussion. It's right here in living color. I can refer back to that and use that as a foundation for my advocacy. So I think the video is really important.
Yeah, my final comment would be nice to your siblings or other relatives, because the value of those relationships becomes irreplaceable when you as a group have to manage what are very difficult situations. I have always appreciated, beyond appreciated, adored my sisters, two of them, one older, one younger. But the relationship that we have, I can't imagine living through what we have done and what we have had to manage with Edith without the close, really refined sense of cooperation that we have developed over the course of our adult lives.
David Hoffman, David Gruenewald, thank you both so much for sharing of yourselves, sharing of your mothers. It's truly a moving presentation, and of course you always bring the highest quality to bear, so thank you. So for those of you interested in David Hoffman's advanced directive, which he mentioned, I'm going to share my screen once more and just share it briefly so you get a sense of what he mentioned earlier. So this is a very simple document. He starts with, "I do not want to be a potted plant," and ends with, "Smile and breathe." And it's just a beautifully simple indication of intention. So I'll just leave that up there for another second and then breathe. Take a moment to breathe.
Sarah, it's not copyrighted.
Great. And for those of you who've been writing in about citations for this presentation, this event will be, it has been recorded, and the recording will be posted to our website in the coming days. And the slides will be linked with the citations included, so not to worry. You'll get an email from us notifying you. So as always, our plug for the Completed Life. If you're on social media, hashtag Completed Life is a great way to notify us that you're here, that you're in on the conversation. We're always excited and delighted to engage in conversation with you. Please, if you haven't already, please check out our website, completedlife.org, for more resources, not only video archives of past presentations similar to this one with experts like David Hoffman and David Gruenewald, as well as advanced directives and different state forms that you can take to your loved ones and your friends and your communities to share with them and have a conversation, as well as your physician and nurse as you see fit. So as always, we look forward to welcoming you back to our future events. Our upcoming event next time will be a week from today, May 6th, from 12 to 1:30 Eastern. It will be our May lunch hour with Danielle Spencer and David Hoffman, welcoming you back, as always, David. And the presentation will be looking at the newly coined term by Danielle Spencer, metanosis, revealing the unknown around narrative identity and disease diagnosis. So with that little cliffhanger, I'll leave you to have a wonderful rest of your evening or wonderful rest of your day, wherever you are in the world. Take care, be safe, and we look forward to seeing you next week at the May lunch hour. Thank you and good night.
Good night, Sarah.
Good night. Thank you.